For the supporters of the Progressive People's Party, it was a long wait. While others waited patiently, others sang and danced in anticipation of that judgment that could determine the future of the party's flag bearer. Then came the judgment delivered by Sophia Denyira presiding, a straightforward one, ordering the Electoral Commission to extend the nomination period up until Tuesday, November 8, to allow all disqualified nominees whom the Commission failed to have an opportunity to correct the mistakes on their nomination form, an opportunity to correct those mistakes. The judge also held that the High Court got it right when it decided to hear the matter, but then exceeded its jurisdiction in terms of powers by ordering the Electoral Commission to allow Dr. Hindim correct the mistakes on his nomination. One thing the lawyers on both sides, I'm talking about Thaddeus Soy for the Electoral Commission and lawyer Ayiko Otu for Dr. Pakwesi Nduom, at least agreed on was that this judgment was a victory for democracy. We can first hear from Thaddeus Soy for the Electoral Commission.
It is a victory for democracy. The court was very categorical in its orders. We came here on 3 grounds: error of law, wrongful assumption of jurisdiction, excess of jurisdiction. And the court agreed with us that whilst there was evidence that there was an error of law on the face of the record, it did not go to the court's jurisdiction, so it wouldn't quash it. It dismissed our second ground, but upheld the third ground.
Lawyer Ayiko Otu shared similar sentiments.
You know, the important thing is the right of the party to say, look, I'm going to court. I'm not going to take to the streets, but I'm going to court. And that is the beauty of the whole thing. And the tenacity of purpose, the willingness of the judges to listen, you know, to the parties and come out with a decision. So I think that democracy is thriving. Constitutionalism is thriving. The rule of law is working. Article 23, always remember.
Now to the chairman who leads the party that has been at the center of this controversy, Nyalote Bree-Hammond of the Progressive People's Party. This gives them a clearance to have their candidate on the ballot and to sell the good message to the good people in the country.
We need to end it. And if we're going to end it, then we're not going to end it with those who have been given opportunity to serve this country for the last 24 years. It will be with Dr. Pakwesi Nduom and the Progressive People's Party.
All cases pending at the High Court have also been put on hold. In the coming days, all focus will definitely be at the office of the Electoral Commission as to how they will be offering candidates an opportunity to correct those mistakes. Joseph Akabile, Joy News, Accra.
Well, hello and welcome. Well, EC versus the Supreme Court. One who say, you know, the people versus Charlotte are saying, you know, what is at all happening? And yes, by all means, we're going to vote on the 7th of December, but is everything going to be smooth where all parties are satisfied that they got their things and information well in time to inform people, maybe the positions of where they have to vote? Is everything going to be all right? And indeed, what at all is happening? Now the Supreme Court says, look, the floodgates are open. EC, hear everybody out. What does it mean? Does it mean everybody coming now is allowed to be, you know, allowed to present a presidential candidate? If not, who then determines which sin is grave enough to be on or which sin is grave enough not to be on? With that, I have 2 fine lawyers in the house to explain things to us. My name is Nana Ansakwa IV, Kwamwedu Masahini, and also your host. Now, with me, sat directly next to me, is lawyer Martin Pebu, who is a private legal practitioner, legal luminary in his own right. If you hear the guy who said that no, there's nothing like a no bailable offense, which is no more a law in Ghana. Well, he championed the cause. He's gotten his name in history. As I always say, let us be legacy hunters. We've left a legacy. And another rising, having a rising lawyer, Eduji Tamoklo, also making waves in the legal fraternity. Eduji, you're welcome.
Thank you.
I can't find you because you've been on the show before. I was just that I wasn't here. But normally I find my first timers get paid, but yet to me Friday. So here we are, and Eduji, let me start with you. let me start with you. What does this mean? I mean, what does it? People are very confused.
Okay. Yeah, thank you very much. As we are all aware, the Constitution requires that the management of election ought to be done by the Electoral Commission.
Mm-hmm.
Now, for the purposes of the Electoral Commission carrying out its functions, the Constitution under Article 51 requires that they must come out with regulations through constitutional instruments to govern how it conducts its affairs. So, as you're also aware, Article 63(1) of the 1992 Constitution provides the form in which somebody becomes a presidential candidate. So with all of this put together, Regulation 9 of the CI governing this 2016 election, which is the Public Elections Regulation 2016 CI 94, provides, and the heading happens to be nominated candidate. Now, what it says is that a returning officer shall inform a candidate that the candidate's nomination is invalid where A, the particulars of the candidate of the person subscribing to the nomination are not as required by law, or the nomination paper is not subscribed to as required by law. And in this case, shall give the candidate an opportunity to make amendments or alterations necessary within the stipulated nomination period. So it is with this in mind that the Electoral Commission announced having invalidated the nomination forms of about 13 of these presidential candidates. Now, Dr. Pakwe Sindum was obviously not happy or enthused about the decision by the Electoral Commission, so he went to court on principally two grounds. That at the time the Electoral Commission purported to disqualify or invalidate his nomination form, the EC had committed an error of law patent on the face of the records. And two, that the Electoral Commission failed to afford him the opportunity to amend or alter before the decision was taken. Now, like as read out, the Electoral Commission had decided to govern its operation by the CI. So ordinarily, the expectation is that the EC will operate on the basis of the CI. So you have a situation where the Electoral Commission, in this case, was unable to afford these candidates the opportunity to amend or alter their document before the final decision was taken relative. And I mean, it's tried law that you cannot condemn a man without giving him a hearing. And in your case, being Nana, I'm sure anytime you say it with your people, sometimes you have to go to Abriwa to go and consult before a decision is given. You also know in our villages, even when you are killing a fowl, the expectation is that you give it some small water before, yes, my senior wants to drink. Now, he's not going to be killed, at least for the purpose of this. You are permitted to give the animal some water with the expectation that it will not come again. Now, all of these were not done. So the High Court judge, His Lordship Justice Eriche Bafo, took the view that having failed by the Electoral Commission to afford these people the opportunity and going ahead to take that decision on them, it was, in his word, extremely perverse and ought not to stand, and for that matter, proceeded to quash. But having quashed that, he gave a consequential order. The order was to more or less extend the nomination period, which the judge said does not exist, and also to make a further order on the Electoral Commission to afford these people the opportunity to amend or alter the document, and for the Electoral Commission to accept same and now make a determination whether or not they have fulfilled all the criteria set by the laws of this country. So that is what the Electoral Commission felt aggrieved by that decision, and therefore decided to go to the Apex Court by, invoking the supervisory jurisdiction of the Supreme Court over the High Court. And the grounds were principally three. One, that the High Court judge, in purporting to give that ruling, committed an error of law patent on the face of the record. And the argument was simple, that Papa Kwesi Ndum deposed to an affidavit. That affidavit in paragraph 8 of it makes the point that the nomination period was to start from the 8th of September to the 30th. The judge's ruling was to the effect that there was no such thing. So his argument was that if the applicant himself had agreed or conceded that there was a period, then it does not lie in the mouth of the judge, so to speak, to do or to give his ruling the manner in which he did. And to that extent, he thinks it was an error on the face of the record. The court appears to have agreed per the ruling that yes, of course, there was an error of law, but the error of law was not so fundamental as to go or to deprive the court of jurisdiction. And to the extent that the court was not deprived of jurisdiction, the court can err within jurisdiction, like we always say. So when a court errs within jurisdiction, you don't come by way of invoking the supervisory jurisdiction of the court by way of seeking to quash, but you appeal. So this is something that you can appeal. This is not something that you should come by way of, seeking the review of the court. And so the court dismissed it. And when the court had jurisdiction, the second grounds that there was wrongful assumption of jurisdiction must automatically fail. Now, it is in respect of the consequential orders made by the judge, the High Court judge, in respect of one, extending the periods, and the nature of orders as to the order on the EC to allow Dr. Kwesi Ndum to amend an order. The Supreme Court took the view that the High Court judge, in that regard, exceeded his powers of jurisdiction in purporting to give that order. Very simple. The complaint by the applicant was that he was not afforded a hearing. Now, the judge goes beyond, because you see, for judicial review applications in the nature of certiorari, you are not substituting your decision for that of the decision maker. So that if the decision maker, for instance, act ultra vires, you quash and ask him to go back and do the right thing. It is not for you to substitute yours for him. So to the extent that there is an order that go beyond giving him a hearing, also afford him the opportunity to amend, and that was problematic. So the court in that regard said, relative to those orders on the Electoral Commission, same will be quashed and same was quashed. However, what the court did was to say that the opportunity of hearing should be given to Dr. Kwesi Ndum and the others. However, on the question, the first question of alteration or amendment, it should be in appropriate cases. What that appropriate case do, I do not know. Maybe my senior will throw more light on that.
Martin, so now the floodgates are open. People, more parties went to the EC this morning, and apparently, there was still, not as welcome as they were expected to. People were waiting a whole day and everything. But what then happens? The EC just sits and then you line up and they look at your error and decide, no, your error, you can't correct it, get out. Oh, your error was just you didn't cross your T, so cross it and join the queue. What happens from here?
Yes, if you ask me, looking at the context of the litigations we've had so far, okay, I would say unequivocally that the EC has to afford all the parties the opportunities to correct their errors. I've heard people make comments such as that the most grievous ones, that the ones that border on criminality should not be allowed, that those ones, the parties should not be allowed to remedy those errors. I think that is wrong. You see, let's not make a mistake. The candidates did not make those errors themselves. Yes, I would admit that those subscribers were subscribing for their candidates. But if mistakes have come, why do you punish the candidate for that? You see? And let's not also forget that these mistakes are in the nature of crimes. The EC says forgery and then what? Double registration. Yeah, okay? These are matters that a court of competent jurisdiction has to hear and determine upon. So for me, to the extent that the EC cannot go to court, that's the Attorney General and the police cannot go to court today and tomorrow to have those cases heard and those people convicted, it stands to reason that all those errors should be remedied. They should allow the candidates to substitute. In any event, how would the candidates have known that this subscriber has already signed for another person? And let's not also forget that in actual fact, those subscribers are even denying. Most of them, you see, you heard the PNC flag bearer say that he took those subscribers to court where they swore to affidavits that they were never involved in any double subscription. You see, so the whole thing becomes murky. And considering that we don't have enough time, I think, look, the EC should eat humble pie. EC should just allow everybody to correct their mistakes. It's better for our body politics. You see, let's not forget even these candidates, especially Dr. Indum and Dr. Mama, are candidates that in everyday conversations and discussions, we've always said that these are two fine, great persons that Ghana would never have as presidents. But minimum, when they join the debate, you see, they help to refine the ideas. Cross-fertilization of ideas, okay, leads to better ideas. So let them join, okay, full scale, like you said. Yes, open the floodgates to them. Mother Ghana would benefit. The EC should stop that posture. You see, that belligerent posture and the arrogance, we should just stop it. Ghana is bigger than all of us. The EC should just eat humble pie. Just accept that they got it wrong, okay, and so they should afford these persons the opportunity to correct their errors, and then we all move on.
Martin, but then one would ask, I mean, and initially when this thing started, there were two schools of thoughts, and the ones who thought that there were too many quote-unquote Mickey Mouse people, and this is the most serious business. I mean, it's the highest office we are applying for. And there are people who, you know, don't, for political correctness, you don't want to mention their name, but you know that, Joe, this is not your race. So, was the EC not doing this to streamline and put the serious people in the game?
Yes, there's a point to that, but as you said, we cannot mention names. And also that is the nature of the Constitution. The Constitution doesn't say that for a person to qualify to stand for the office of president, the person should have a certain minimum in terms of educational qualification and those things, okay? Yes, and besides, well, but let's be careful, you know, in this world, some of the greatest inventors and the rest haven't had the so-called university degrees that we have. So for me, my posture is that, look, to the extent that they've thought they've seen themselves fit and have stepped up, they should be given the opportunity. That's it. And also, let's not forget, how about Dr. Mahama and Papa Kwesi Ndum? These are, as I stated earlier on, very fine gentlemen that, I mean, you know, some things that we say behind the scenes. In actual fact, they are, if things were right, they should be in the forefront of these elections, okay? So, to the extent, somebody even said it somewhere that perhaps if Papa Kwesi Ndum, Mahama and Kunedu were not in that category of disqualified persons, perhaps we wouldn't have had all these litigations. But, well, we may never know. Bottom line is that once the Supreme Court says, afford them the opportunity, let us do so. Yes, it should help our governance.
I think, Nana, there is a more fundamental thing, and that's my view in principle on this matter. I strongly believe that the only person who has the power to disqualify anybody, the electorates. They should have the power to decide that we want Kweju, we want Ama, and that determination must rest solely with them. And that is where I empathize with, you know, some of these candidates. But like you rightly pointed out, yes, there has been some commentary that some of the candidates have not lived up to a certain expectation because, first of all, this is not running for maybe a school prefect or something, but you're going to manage the destinies of about 27 million people, and it requires a certain level of this. But again, if at the end of the day, the people said, it is Kweju that we want because he can crack jokes, or we want this man because he's straight-faced, or this person, because we are so stressed, we want a president who will not stress it up. I mean, solely for the suffrage, the universal suffrage of the people. But there again, the issue that this process had been used more or less to sieve. I'm sure maybe if we go back to the Bible, when Jesus said, let's leave the chaff and everything, the wheat and the everything there. On the day of harvest, which is actually the election, you know, 7th December, there will be a weeding of the chaff or the weed out of this whole process. I strongly believe that we've gotten to a point where, like he said, time is also not on our side. So, and I'm already aware that the Electoral Commission had written a love letter to Dr. Pakwesi Ndum, indicating that they want the presence of one ASEDA, Richard ASEDA, and also pointing out other issues that have come out. Possibly now the Electoral Commission had enough time to sit down and scrutinize the documents of Dr. Pakwesi Ndum. And in so regard, they are beginning to see more and more things. When those matters do not, I mean, there are clerical errors and what have you, I think that they should be given the opportunity, so to speak, to amend or alter. My only difficulty in all of this is that we cannot also use CI 94 as a clock to perpetuate criminality. And I make this point because, you see, if you have a situation where Article 63(1) requires the number of endorsers, and in order to get the number, a candidate decides to maybe up the numbers of one person or two or more. So like in this case of PPP, and now I can speak to it because the Supreme Court has given a decision. The person endorses you in Central Region and then goes to another place in Volta Region to endorse you. If this case is established beyond reasonable doubt that that is what in fact happened, then it will be problematic. That will be problematic. Because you see, it's in quadruplicates, 4. If ASEDA has signed here, and in signing this other document, he made a mistake and was able to do the remaining 2, no problem. But here, ASEDA signs as number 4. Then you open to say 38, page 39 or something. Then you find another ASEDA, but this time around, he's using a different signature. That's problematic. I wonder if the power to amend or alter.
The numbers are the same. The voted ID number is the same?
The same, but then he signed differently. Because you see, like I told you, the Constitution requires really that you need endorsers in each district in the country. So he does one in Central Region, comes somewhere in Volta Region and decides to do it, maybe to add up to the numbers. I mean, the question is, can all of this be amended or altered? Yes. Especially so when my fear is that, you see, you have a situation where the person in this case has sworn what you call statutory declaration, that to the best of his knowledge or whatever, the information or the representation in the document are in fact true. It becomes problematic. If you recall, in the case of Honorable Adamu Dramani Sakande, his conviction was on the basis of false declaration on parliamentary nominated nomination forms. That is what, you know, landed him in what you say, in prison. So we need to be careful how we take some of these things. But I do not have any problem at all relative to they having to amend. I think sometimes, like I pointed earlier, in principle, the people are the best deciders when it comes to who should lead them.
Now, if I may make a point, I'm further fortified in my opinion that whether fraud or no fraud, they should be allowed to rectify, because, you see, the Regulation 9.2 says that when the EC looks at the forms, it should allow, if I may just look at the instructive portion, it says that shall give the candidate an opportunity to make amendments or any other alteration necessary, okay, then within the stipulated nomination period. We know that by the judgment of the court, the nomination period is been extended anyway. But let's come to the make amendments or any alteration necessary. You see, this CI follows from the Constitution. Now, if Parliament intended that if you see something in the nature of fraud, punish the candidate for it by invalidating his nomination, I think that nothing stopped Parliament from stating it here. But to the extent that Parliament has not categorized the amendments to be made or those ones that should be used to disqualify a candidate, I think that any error at all, they should allow it to be rectified. If the EC is so minded in making sure that people who have committed fraud pay for it, so be it. The EC can pursue that one as a separate matter.
HG was saying that you sworn a declaration that what I'm giving is true.
Yes. Yes. Banana, these are 432 persons, 432 subscribers. Look at the time. In any event, day one, as soon as the EC announced these disqualifications, I've always been saying that the EC did very poor planning in respect of this matter. That is something that the EC needs to sit down and do introspection. You are giving such a national exercise and you don't set adequate time. You force people into 2 weeks or is it 3 weeks? Why such a poor planning? They should have planned well, make sure that they set out the timelines well and giving adequate time for these mistakes to be remedied. So that's something that going forward the EC needs to do.
Senior, if I may ask, in respect of the planning, would you dare say that somebody giving, say, 8th September to 30th was
it
not
was
enough
about
time?
13th. They didn't pick the forms on the 8th.
No, but the 8th was supposed to be the time.
Oh, I think that they chose to come and pick on the 13th from the...
Because, like I told you,
14th.
even the PPP, in their own paragraph 8, in the affidavit deposed to by Dr. Pakwesindu, the point I'm making is that he even deposed the fact that the nomination period was to start from the 8th to the 30th. However, in court, they considered it was a mistake they made, that it was not, they didn't know about the nomination period. But obviously, they picked the form someday.
Yes, but it was just about 2 weeks. So moving for a council, I get the point. Let's not make a mistake. Just as the EC itself was forgiving very egregious errors that they made in the 2012 elections, which cost this nation a lot, they should have learned from it that in election matters, you cannot use these administrative problems to stultify or cancel somebody's right.
What do you think would have been the legislature's intention in saying that there is a situation where a form can be invalidated?
Or that it was meant for situations where the EC haven't seen the errors, and pointed same out to the candidate. That candidate refuses to rectify them. And look, that is it in under 3. It says 9.3. Where a candidate fails to comply with sub-regulation 2, the returning officer shall consider the nomination paper of the candidate as invalid. So where the EC has pointed out your errors to you, and you say, oh no, I'll have nothing to do with any remedying, I'll not correct any mistakes.
Is it not a contemplation that there are some errors that cannot be amended, or the right or the opportunity to amend or alter must be construed within what is amenable to that amendment process, so that if, for instance, the thing borders on plain criminality, without having to secure conviction, that should be enough grounds for you to invalidate the form. Because you see, during the oral hearing, His Lordship Justice Benin asked a very simple question to Siniaiko Otu. He asked, the right to amend or alter, would you therefore say that where a person, for instance, makes a representation on his age, and it turned out that he cannot be of that age, are you saying that the right to amend or alter should be automatic to that person?
Oh, I would have said yes. Because look, mistakes
obviously,
happen.
that was the answer.
Yes.
Whatever, Siniaiko to get.
Because election matters are different. You see, let's not, way just as
Ekweadonkos, for instance, running mate, is obviously, we cannot tell as we speak whether he's 40 years, 42 years or something. In this case, you said it should be remedied by way of she going to replace a new running mate.
Exactly. Once it's within the period.
No, that's problematic.
Problematic for what reason? Let's not forget. You see, Nana, the way we do this is when we are interpreting law, Council, you know very well that the way we interpret the Constitution is different from the way we interpret ordinary statute. And election matters. You see, the 2012 election, if you read the judgment, they mentioned it. You see, election matters are also peculiar. Don't forget that these people have hundreds of thousands of supporters behind them. These things create problems.
Your question is more like expediency, or
oh, don't call it in the spirit of the law. You see, when you say expediency, then you are moving out of law. Let's put it within the law, because within the law, yes, there is space for all those considerations. That you would look at the situation.
But you agree with me that
the man has a right.
The moment you even go into such considerations as to the person having supporters, the person having this, it's a subtle admission that yes, there's a wrong, but in order to hold a certain polity, a certain people together, let's allow it. Then you concede.
It's a question of words. So maybe to that extent I'll concede. But we don't write it plainly like that. The way it is written is that because he has a right, okay, you cannot punish him for the wrongs of his subscribers. You see? Yes,
no, but at that point, it becomes your work.
It's not all the time.
No, at that point, it becomes your work. That is why you swear you do the statutory declaration, making the point that the content of the document are no longer that of your subscriber, but yours.
Yes, but we know that practically, Council, let's be very practical, 432 persons within 2 to 3 weeks to verify all these persons in circumstances where these parties are even constrained. They are all complaining that they don't even have an up-to-date version of the voters register and all that. I think, look, this thing, the EC just made some errors. We've all learned from it. Let's move on. These people, to ensure that there is peace and quiet, give all of them the opportunity to remedy. Then beyond that, if Parliament thinks that next time things that look like forgery should not be allowed to, I think it's within the EC's right to send a new CI.
I have a difficulty where, for instance, we are saying that in the absence of these words being clearly stated, that when it borders on fraud, when it borders on perjury or something, there wouldn't be any right of amendment. Don't you think, therefore, that this law will invariably become a conduit to perpetuate criminality? Because then now we hide behind it, that because these words are not expressly stated in the enactment, it's a saving grace.
Oh, no, at all. I made the point earlier that when the EC finds those people, even in this current situation, the EC has already reported to the police and the Attorney General. The EC reserves the right to pursue their prosecutions, but the EC should allow the candidate to substitute, give trouble-free people, so to speak.
You're having a situation where you have your elected president, whose forms obviously borders on criminality. He's in office, and the EC cannot continue with the prosecution. What becomes of that?
Oh, don't presume so, because as counsel, we shouldn't say that. We know there are problems. The Attorney General and those, but if you presume so, then the logic is that all these
Nana, you agree with me? Assuming one of these candidates who had been referred to the police turns out, goes to win the election, he is president. What becomes of the criminality? Holding abeyance?
No, then, counsel, the logic of your argument suggests that you've never been happy with the AG being under the president. Okay, that's the AG being appointed by the president.
No,
right?
I mean the constitutional structure now agrees.
You should have pursued
it.
No. I mean,
yeah, so what then happens now? Assuming they all come, and the EC says, well, Party A, somebody didn't sign, go. Yes. Party B, you bring me a new vice president.
And they will return to
Party
court.
C,
they will return to court. That's why I said, look, we don't have enough time. And I'll say something very commendable now.
For me, that's what I see.
You see, but in law,
we don't have time, and therefore let's hurry it. Let's allow everything to go, because time. So that if this thing had happened 4 months ago, you'd agree with me that you'd allow the process to take its natural course. I think that the lesson in all of this is that situations where we allow, for instance, the electoral calendar to come up in all this form should not be entertained.
Good.
A year to election, we should know who our candidates are, so that all the other small issues can be done. Today, as we speak, thankfully, the Electoral Commission has succeeded in getting all their presiding officers. They have been to the various district magistrates. They have sworn their respective oaths. Today, in terms of the parliamentary process, which is more difficult, because for presidential election, it's one constituency called Ghana. So with the ballot printing, you can just print and it's easier. But the constituency, you need to do 275 of them. So that's where the difficulty is. It appears that we don't have a problem in that area. The same presiding officers will do both parliamentary and presidential. So we are better safe in that regard. The point now relates to having to ballot the presidential. At least I think that for the purposes of voter education, because remember that the third largest political party in Ghana is the rejected ballot political party. The last time, they had over 200,000 people having to do that. What it also means is that people do not have enough time to really know how the ballot paper, the arrangement of their respective candidates, the kind of education that should go, so that you know that when you are tampering, this is how you ought to do it. We are having barely, in fact, what it means really is that we're going to have like 2 weeks.
Yeah, you see, we already short. The rate of the election is already short because it says 30 days to the election. That's when it should be issued. So we are already short by maybe a day or two. So from what you said, your last point was that you want to call it expediency. Fine, I'll concede. But in law, we'll say in the spirit of the law, so that legally we have precedent. You know, in law.
But this is so unruly.
Yeah, no, it's good for our body politic because Nana, you see, if the EC makes a mistake and disqualifies any other.
But now they're finding more faults, you know, in the
they should allow the correction.
Clerical errors, very clerical. Because as we speak, we do not know the nature of this.
Yes, whatever it is. That's why I said the EC itself brought these problems onto itself. So for having inconvenienced these parties and their candidates, the EC should also be magnanimous, open its doors, let's correct everything and move on. Because if we don't make those kind of concessions and you insist on disqualifying some candidate, it means that they will run back to court. And you know, so far the EC has done something that's very good. I haven't seen that in public office in a long while, where each time that any person goes to court against the EC, usually, you know, when there is an application for injunction,
they stay everything.
Yes, they stay everything. So
without
so far,
even the application.
Yes.
Yeah.
So far, that's a very commendable posture that the EC is taking when it comes to lawsuits against them. Every time there's an application pending against them, they stay their hands. They don't do anything to overreach the court. So if you go by their past, what do you call it, posture and the way they've gone about business, it means that if they disqualify any candidate now, and the candidate runs to court, then as usual they say, oh, we'll hold our hands.
But if you read the decision well, I get the understanding that when the matter borders on the merit-based approach, you may as well come by way of a petition.
Yes. So
that in this case, if the Electoral Commission, having granted the people a hearing, then proceeds to, on the basis of A, B, C, D, disqualify you, then in this case, you may not come by way of judicial review any longer. You may have to come by way of petition.
You can apply for an interlocutory injunction. So you apply for interlocutory injunction.
But the petition itself should be in such a way that you should be able to invoke the jurisdiction of the court in order to even apply for the interlocutory injunction. And you know, per our electoral laws, at the stage where you can apply for a petition, you cannot do it before the election.
After. And
exactly.
Don't forget legal
issues.
ingenuity. Don't forget that these hearings that the EC is going to give, if the hearings don't amount to hearings in law, these parties will be back in court that they've not been given a fair hearing. Not being given a fair hearing itself is also another ground. So if they come that the hearing itself was irrational, okay, there wasn't any proper opportunity for me to remedy, they will come on those same judicial review grounds. So you see that, and as I said, because so far the EC has been staying in his hands. Anytime somebody sues, saying that the EC has done something wrong, the EC stays off and says, we'll wait for the court to determine. So if somebody sues again and says, the opportunity you afforded me was not an opportunity in law at all, so he's back in court, that the court should order the EC to give him an opportunity, then it means the EC will stay in his hands. Meanwhile, by the CI 94, the EC has to issue the rate 30 days to the elections. So you see that will be caught.
What's your comment on the EC's perceived posture?
I think that, well, like my senior pointed out, if you want to apply the law to its latter, it comes with its own inherent problems. Yeah. Because obviously there are some people who will be falling by the wayside. How do you create that saving grace for this number of people? So maybe, just maybe, the posturing of the Electoral Commission looking like we want to litigate. There must be a different, posturing. That posturing should be one of engagement, more of a constructive engagement, so that all the parties involved in this electoral management process will come out with an amicable solution where we can all have an election. I think that maybe going forward, because of the time not available, maybe that is how we should take this whole matter.
So your colleague, Samson Ladia, from the beginning was saying that the EC should go for arbitration, rather than the
No, because you see, the matters really were not, you see, you know what is arbitrable, okay? Even in law, we know what is arbitrable.
You want to arbitrate constitutional matters.
Exactly. So if the thing is not arbitrable, you cannot subject it to arbitration. I mean, for instance, if the claim was that you have wronged Article 63, you cannot subject a constitutional matter to arbitration. But if it was a minor issue within a political party, or maybe like today, the MPP is making the claim, we have not gotten the proxy list, we have not done this. These are matters that between the two parties, they can go for arbitration and look at how well that we can get to the register without you having to delay or creating any more problem. But the best question in this case, and with all deference to my senior Samson, is that the matter must be arbitrable. If it's not arbitrable, you cannot resolve it. If it borders on criminality, I do not know how you can resolve this. I'm just saying, if it borders, I'm just saying that if it borders on criminality, I do not see how you're able to use arbitration to resolve it.
The reality is that, all over the continent, I don't know what percentage, but it will probably be a greater percentage of countries that are falling is through to elections. And even in our own country, anytime we've come to the brink of panic, is election. I mean, with all this in view, can the law then be twisted and something in favor, or the law is the law, whether the country falls or not?
Maybe I'll defer to what Jesus said. He said the law was made for man.
Not man. And it's in the law. And that's how we do.
So you have to look at all these things.
And that is where my senior speaks of the spirit. Because the spirit is what we don't see, but it speaks to aspiration, aim, purpose. All of these things, once you put it together, then you can say, okay, maybe the right, the framers, what they thought in fact is that A, B, C, D ought to be done, so that you do not use the law now to become a sword unnecessarily. It should also, in some instance, provide a shield to protect all of us, to protect the collective. And that works. And I remember very well, if you recall, in 2012, on the creation of the 45 new constituency, in the matter of Ransford France, the Attorney General Electoral Commission, the court felt that the question before it, that there was no CI to regulate the exercise of discretion by the Electoral Commission because it's not a judicial officer, or it was not exercising a judicial power. That thing, notwithstanding the absence of it, they will save the 45 constituencies.
Exactly.
And a whole lot of argument. In the words of that, by not doing it, will create a nuclear meltdown and all of those things, just to save the situation. So maybe, going forward, we should adopt that posturing. At least so we can have the election on the 7th.
This one says, a whole lawyer, Charlotte say, who is surrounded by lawyers behaving like a layman. Tria, EC is losing their small integrity they have. I
do not think so.
Brekum. Well, good, because the next one comes to you then. Nana, please ask Lawyer Tamaklo and the NDC for me that why are they always behind the EC? Tell him that if so it was just this one is Shipman Atunsu. Nana, I commend the Supreme Court for throwing out the EC again until Madame Charlotte herself learn to be herself, and the NDC will continue to push her for these embarrassment. Change must happen. Joy TV, the finest. How are you doing? I mean, what's politics is perception. And once it's not changed, becomes true. There's this perceived thing that, look, the EC, you know, is either leaning towards the NDC or the NDC is leaning towards the EC or singing from the same hymn book. You know, there isn't clear evidence, but we all perceive this.
But Nana,
and it's politics.
See, Nana, you know my political persuasion.
Yeah.
Look, on any day, I would prefer that there is a PPP on the ballot paper. Because you see, for the opposition, they are all eating from the same bowl, the change bowl. So if you have them eating from the same bowl, then the opportunity for them to split their front is better for you, the incumbent. When you are in opposition, you prefer that you are the only one, so you can hit the incumbent one-on-one. Then it becomes you or them. But the moment you are an incumbent, it's always better you have stronger opposition parties, because then what happens is that they feed from the same bowl and they're able to split their front. Look, Buhari, if you recall, what he did was to bring as many of the strong major political party or opposition party under the umbrella of APC. And he was able to move against the PDP very strongly. In this case, I would prefer that there is a certain Hindu doctor on the ballot paper against Nana Addo Dankwa Akufo-Addo, because then they will be eating from the same thing. So on any front, I would prefer that. So why should we encourage a situation where it puts you in a very tight corner, where more or less you are basically doing like a runoff?
Okay, let me take this one. This one says, if it's the same, and Martin, when I come back, I want you to respond to this. It says, if it's the same team of the EC that was working with Dr. Afari-Gyan, then with the way things are being messed up under the current chairperson, it will be either that she's not taking advice from the other 6 commissioners, or they are ill advising her deliberately to pull her down. This is Alaji Kus in Yendi. I'm coming straight back and find out what exactly is happening there. Well, interesting. So we're trying to find out whether the 6 commissioners that are there working with Afari-Gyan are the same commissioners. If it is it that Charlotte is not heeding to the advice, or are they deliberately giving her false advice to pull her down? Martin is going to answer that. But the other one says, hi, good evening. Nice topic, great brains. Please, my question is, can the EC really now disqualify any candidate, especially when the answers to what causes a candidate disqualification has been made known to the public? I am Pedi in Ejura. But the EC, I mean, is it the same commissioners that you used to work with?
Most of them, right? Yes. I think since this government came, they fully appointed one, right? Yes. So most of them were there in the previous regime. But you know, Dr. Afari-Gyan was noted for a certain personal trait. He was decisive, and I think generally he appealed to the masses. That is what we don't seem to see in this current EC. So that's why we are saying that the EC probably needs to tone down. You know, you need to tone down to come out and say that the candidate should have taken this thing serious. If you want to be president, you should know. Oh, I didn't think that should come from an EC chairperson. No. There are certain comments that people of a certain stature and office shouldn't make. That is for ordinary citizens to make. But you come out in the media and then you say all manner of things. It was just totally uncalled for, and it didn't fit the office of the EC. Okay, so I think moving forward, I'm sure they've learned their lessons loud and clear. They need to tone down their posturing, okay, tone down, be more conciliatory, and as Eduji said, be more constructive in their public engagements. It's very, very important. But when you come out belligerent, I have my rights, I will exercise them. Oh, no, it doesn't sound good. Look, let's not forget, the Constitution makes it clear that in Article 2958, yes, that the EC, when they say in the Constitution that a body is independent, it doesn't mean that a court of law cannot make orders, okay, directing that public body to perform functions in a certain manner. Yeah, it's there in the Constitution. Even without a Supreme Court decision, the Constitution makes it clear that when in the Constitution it is stated that a public body is independent, that does not mean that that body is not subject to directions from a court of law. So this thing about we are independent, we will do this, we will do that, it doesn't help. We are all learning, you know. Of course, we cannot run away from the fact that Ghana is a developing country, so sometimes, you know, the level of discourse and those things, you know, there's a certain context.
Ike Mbrekum comes and says, Nana, I want to understand something. Does the referee cares the nature of the pitch that players play their match? If no, then why is it that EC is making all Ghanaians believe that she is interested in who wins the elections? Oh, Mike, that's
as you said. Let's support the EC moving forward. I think the litigations have come to an end. Let's support the EC. Let's move forward.
But I think that we should use a platform of this nature. Should also carry our people along. With the electoral process, I've been party agent for a long time. If you look at the electoral process, the influence of the presiding officer in a presidential election, being the electoral commissioner itself, in, say, manipulating the electoral process, is the remotest thing I have ever noticed. Because you notice that at the polling station, where, unless, of course, you will say there is a delay in bringing the ballot papers and what have you to the polling station. But the moment the election starts from, say, 7 a.m., and it ends at 5 p.m., all the results collated is done openly, declared openly, signed by the respective political parties. It is brought to the Constituency Coalition Center, collated from all the respective polling. It is taken to the Regional Coalition Center. All of these things are mechanisms for checks before it rather gets to what you call the strong room. It is at that point that the presiding officer here, the electoral commissioner, will even see what the data is. At that point, it's beyond manipulation. So I think that we should let our people also appreciate the inbuilt mechanism in our electoral process that makes the manipulation. In fact, it means that she has to be in 29,000 polling stations all at the same time.
changing the figures.
Absolutely. There's this president who says the one who votes decides nothing. The one who counts decides everything. So
in the case
confidence in the system.
In the case of Charlotte Osei, or maybe the electoral commissioner, she's not even the one counting. She's just a calculator.
It's a calculator. well, I always give you the number, and it's 024-366-2001. 024-366-2001. They're Tantis Fashion, and they make me my shirts for the show, so give them a call and order yourself a nice made-in-Ghana shirt to support the local industry, just by Nyawo Clinic in Airport. But I want to say thank you very much, Martin Pegbu. Thank you very much to Aduji Temaklo for coming to legal education this evening. I'll go home a better lawyer than I came to work today. Folks, tomorrow we'll be back to do this all over again. And gentlemen, thank you so much.